Hi, I'm Mariana Bettman of the University of Cincinnati College of Law, and I'm sorry I can't be with you today in person. But let's get started on the top 10 cases from 2014 from the Supreme Court of Ohio, starting with Bank of America versus Kushta. Civil procedure geeks, get ready. This is a bit of heavy sledding, but continues to draw the greatest interest of any subject on my blog. The case is an ongoing part of the foreclosure mess in which the bank or other lender that brings a foreclosure action doesn't own the note or the mortgage at the time suit is filed. This is a national mess, not a local one. In 2012, in the landmark decision of Federal Home Loan Mortgage Corporation versus Schwartzwald, a case in which the mortgage company did not own the note or the mortgage at the time suit was filed, the Supreme Court of Ohio held that a plaintiff's standing must be determined at the time suit is filed because standing is necessary to invoke the jurisdiction of the common pleas court. Lack of standing cannot be corrected before the entry of judgment. Since the mortgage company did not own the paper at the time this suit was filed, it hadn't suffered an injury, so it didn't have standing to bring the suit. Okay, now Part 2 for the Kushta case. In 2002, the Kushtas signed a note and mortgage with Wells Fargo Home Mortgage, Inc. In June of 2010, Bank of America filed a foreclosure action against the Kushtas, attaching a copy of the original note and mortgage to the complaint and claiming to be the holder of the note and the assignee of the mortgage. But at the time the bank filed this foreclosure action, it was neither. The Kushtas filed an answer pro se challenging the standing of the bank to bring suit, arguing there was no proof of assignment of the mortgage to the bank. Later, in June of 2010, after suit was filed, the bank cleaned up the paperwork, receiving the proper assignment of the note and mortgage and recording the assignment. In August of 2010, the bank moved for summary judgment with the proper paperwork attached. The Kushtas did not respond to this motion. The trial court granted summary judgment to the bank and entered a decree of foreclosure. If the Kushtas had appealed this judgment, this case would have had the same result as in Schwartzwald, but they didn't. About a week before the scheduled sheriff's sale, well after the time to appeal had passed, the Kushtas filed a Civil Rule 60b-3 motion to set aside the foreclosure judgment, arguing, among other things, that the bank lacked standing to bring the action because it wasn't the owner of the note or the mortgage when suit was filed, and that the bank had committed fraud by falsely claiming it was the owner. The trial court denied the motion for relief from judgment. The Ninth District Court of Appeals reversed on the authority of Schwartzwald and certified a conflict to the High Court, which accepted this conflict question. When a defendant fails to appeal from a trial court's judgment in a foreclosure action, can a lack of standing be raised as part of a motion for relief from judgment? The short answer to this question was no. In a 5-2 decision written by Chief Justice O'Connor, in which Justice O'Neill dissented, joined by Justice Pfeiffer. The majority rejected the Kushtas' reliance on 60B for two reasons. First, the court agreed with the position of the 10th District Court of Appeals in the conflict case that the type of fraud covered by Civil Rule 60b-3 is deceit committed to obtain a judgment, like filing a false affidavit, not to conduct that would have been a claim or defense in the case itself. Second, the court held that the challenge to standing should have been raised during the foreclosure proceedings, and an adverse ruling on that issue should have been appealed. Since it wasn't, res judicata prevents the use of Civil Rule 60B as a substitute to collaterally attack the judgment. This argument was repeatedly made by the bank's lawyer at oral argument. The subject matter jurisdiction part of this opinion is trickier. The Kushtas argued that the bank's lack of standing meant that the court lacked subject matter jurisdiction over the case, and thus the judgment was void ab initio. This certainly seemed like a logical argument to make after Schwartzwald, but the court rejected it. Because Schwartzwald involved a direct appeal, it's of limited applicability to the attempted collateral attack in the present case, O'Connor wrote, but it's not entirely clear why that is so. The court also felt a need in this case to clarify jurisdiction over the subject matter. At oral argument, Justice O'Donnell, who was the author of Schwartzwald, was clearly very concerned that Schwartzwald was being misinterpreted. He was a very aggressive questioner in Kushta, commenting that what the court had said about lack of standing, quote, had morphed into a lack of subject matter jurisdiction of a court to hear a foreclosure case. That isn't anything at all what we said. It's being transcended into something it doesn't say. Maybe we reference jurisdiction, but the fact is it's the right of the litigant to present a claim. If you don't have an injury, you don't have a right, unquote. He specifically asked if the court needed to clarify its holding in Schwartzwald, and the lawyer for the Bank of America clearly argued, yes, it did. So, while the court acceded to the suggestion that it needed to clarify what it meant about subject matter jurisdiction, I'm not at all certain that it did. First, the court defined subject matter jurisdiction as the power of a court to entertain and adjudicate a particular class of cases, a power that exists without regard to any particular parties to a particular case. It's beyond dispute that Ohio's common pleas courts have subject matter jurisdiction over foreclosure actions. So the Medina County Court of Common Pleas had subject matter jurisdiction over this foreclosure action. A party's lack of standing, in this case the banks, means the party had no power to invoke the court's subject matter jurisdiction over that particular case, but it doesn't mean the court lacks subject matter jurisdiction in foreclosure actions. Any error in exercising jurisdiction over a particular case makes a judgment voidable, not void. For the dissenters, Justice O'Neill sees this case as both simple and is controlled by Schwartzwald. The bank lacks standing to invoke the jurisdiction of the common pleas court, and the lack of a justiciable controversy affects the subject matter jurisdiction of the court most fundamentally. O'Neill points out that the court in Schwartzwald stated more than once that standing is jurisdictional, and that a party must have standing to invoke the jurisdiction of the common pleas court, and that standing must be determined as of the time of filing the action and cannot be cured post-filing. He cannot accept, then, the logic or the implication of the majority's view that in this case the bank's lack of standing at the time of filing does not affect the subject matter jurisdiction of the court in which the party is attempting to obtain relief. He criticizes the majority for preserving a void judgment. Justice Pfeiffer joined this dissent. Now, what I'm hearing from my civil procedure geek friends is that the majority's creation of some kind of third way on subject matter jurisdiction, in which standing is a jurisdictional issue, but not a subject matter jurisdictional issue, is rather dubious, but that is now the law of Ohio. There are a couple of other foreclosure issues that have been argued recently. In one, the issue is whether Schwartzwald requires a plaintiff to attach evidence of standing to the complaint, or whether it's sufficient for plaintiffs to clarify standing through corroborating evidence provided at a later stage of the litigation. In the other case, the issue is whether a plaintiff in a foreclosure action must have an interest in both the note and the mortgage to have standing, and if not, whether it's sufficient for the plaintiff to have an interest in either the note or the mortgage. The next case is State v. Herring. This is a post-conviction case in which alleges ineffective assistance of counsel during the sentencing phase of a death penalty appeal. The spotlight is on trial counsel's investigation and presentation of mitigating evidence. Willie Herring, barely 18 at the time, and 5 other men robbed the Newport Inn, a bar in Youngstown, shortly after midnight, April 30th, 1996. 3 people in the bar ended up dead and 2 others seriously wounded in the resulting gunfire. Herring was later found to be the ringleader of this massacre. Herring was convicted of 3 counts of complicity to commit aggravated murder with the attendant death penalty specification and several other felonies. Herring's trial counsel hired Thomas Hardy as the mitigation specialist in this case just a few weeks before trial. That trial resulted in a mistrial, giving counsel and Hardy about 5 more months to do their work. Hardy failed to interview family members other than Herring's mother. He failed to obtain information about Herring's dysfunctional childhood, the murder of his father when he was a young child, his gang involvement, substance abuse, his mother's drug addiction, his low IQ, and his possible organic brain impairment. He failed to get the specific records necessary to do the investigation. At the penalty phase, Herring's 2 lawyers opted to present a positive mitigation theory, choosing to keep Herring's negative family background and criminal record from the jury. Herring's mother and sister testified about his good and loving relationship with his siblings. Herring did not testify. No expert testimony was presented to the jury, and no medical or neurological examinations were performed. Herring's lawyers presented evidence that none of Herring's accomplices had received the death penalty. Herring's youth was also raised as a mitigating factor. The jury recommended death for all 3 aggravated murders. The trial court sentenced Herring to death, and Herring's conviction and sentence were upheld by the Supreme Court on direct appeal. So Herring filed a petition for post-conviction relief in September of 1999, alleging ineffective assistance of counsel during the mitigation phase of his capital proceedings. As part of the post-conviction petition, the retained mitigation specialist Thomas Hardy stated in an affidavit that he failed to complete most of his identified tasks and provided a substandard investigation. Other affidavits included one from a psychologist, Dr. Jolie Brams, who stated that jurors received no meaningful psychological information about Herring. She described Herring as a feral child who was raised in an environment in which basically every parental figure, caregiver, family member, and associate was involved in illegal activities and significant drug and alcohol abuse. She also opined that a neuropsychological and psychiatric evaluation should have been performed and followed up. Other family members supplied affidavits about Herring's gang involvement, life as a drug dealer, and mother's drug use. Herring's post-conviction petition was denied by the trial court, but the 7th District Court of Appeals reversed in a split decision and remanded the case to assess whether trial counsel knew the shortcomings of their mitigation specialist and whether their decision to present only positive mitigation evidence was reasonable. After a hearing at which trial counsel testified, but Hardy did not, the trial court found that Herring's lawyers were not deficient and again denied the petition. Herring filed a second appeal. This time the 7th District Court of Appeals vacated Herring's death sentence and remanded for a new sentencing hearing after finding that the trial court had abused its discretion in denying the petition, and the appeal of this decision is what's before the Supreme Court. In a 4-3 decision written by Justice Pfeiffer, the court granted Herring's petition for post-conviction reliefs on the grounds of ineffective assistance of counsel and failing to properly prepare the mitigation phase of the proceedings. Joining Justice Pfeiffer in the majority were Chief Justice O'Connor, Justices French and O'Neill. Justice O'Donnell wrote the dissent for himself, and Justices Lansinger and Kennedy. Despite the fact that this is a very long opinion, the holding in the case is really quite simple. It's the responsibility of trial counsel to conduct a full mitigation investigation and to present an adequate mitigation theory. Herring's trial lawyers failed to do that in this case. Trial counsel can't foist the blame for an inadequate investigation onto their retained mitigation specialists. Think of this responsibility as kind of like a non-delegable duty, to borrow a term from tort law. Generally, strategic decisions by trial counsel are not a basis for reversal, and the state took that position in this case. But the court agreed with Herring's appellate counsel, who really pounded on this point at oral argument, that a positive mitigation theory can only be selected after counsel had made a complete mitigation investigation. Here, a positive mitigation theory was unjustified and ineffective because the decision was made before a complete and thorough investigation had been made into Herring's background. Applying the test of Strickland v. Washington, the court held that Herring was prejudiced by the ineffectiveness of his counsel in this case because there was a reasonable probability that the penalty phase outcome would have been different had the lawyers done their job properly. The position of the dissenters was that Herring failed to rebut the presumption that his trial counsel performed competently, nor had he proven prejudice. O'Donnell would accept the state's argument that defense counsel were not on notice of the inadequacy of the investigation done by their mitigation specialist, but that even if they should have known, there was no proof that a more in-depth investigation would have turned up anything they didn't already know. O'Donnell would find that none of Herring's claimed errors are anything more than disagreement over trial strategy, which is the province of defense counsel, not the mitigation specialists. Finally, O'Donnell would find that even if his counsel were deficient, Herring failed to establish prejudice, citing recent U.S. Supreme Court precedent that evidence of a dysfunctional family, drug abuse, and gang involvement is not necessarily clearly mitigating. The case will now be sent back for resentencing. No one at argument was certain whether life without the possibility of parole would be an option at the resentencing, which has not yet occurred. The next case is State v. Long. To better understand the context of the Long case, let's look briefly at a trio of cases from the U.S. Supreme Court on the treatment of juvenile offenders. In 2005, in Roper v. Simmons, the U.S. Supreme Court banned the death penalty for juveniles who committed homicide offenses before they were 18. In 2010, in Graham v. Florida, the court held that life without the possibility of parole for juvenile non-homicide offenders violated the Eighth Amendment. In 2012, in Miller v. Alabama, the court held that imposing a mandatory sentence of life without parole on a juvenile is cruel and unusual punishment and thereby violates the Eighth Amendment. The building blocks from those cases, as articulated by Justice Kagan and Miller, are that the hallmarks of youth in this context are immaturity, impetuosity, and failure to appreciate risks and consequences. In Miller, the court also noted that because it held a mandatory life without parole is unconstitutional for a juvenile offender, it didn't need to decide if the Eighth Amendment required a categorical ban on life without parole for juveniles, but noted, given all we have said in Roper and Graham, we think appropriate occasions for sentencing juveniles to this harshest penalty would be uncommon. Uncommon, but not forbidden, because in Ohio, the imposition of life without the possibility of parole on a juvenile homicide offender is discretionary, not mandatory, so it doesn't run afoul of Miller. Eric Long, who was then 17, along with two adult offenders aged 25 and 26, was involved in two separate shootings in Hamilton County. In one, assault-style weapons were fired into a house in Lincoln Heights. Several days later, again with assault-style weapons, Long participated in the killing of two men in a car on I-75. All three co-defendants, who were tried together, were found guilty of 2 counts of aggravated murder and numerous other felonies related to the two incidents. At a joint sentencing hearing with the two adult co-defendants, Long was sentenced to consecutive terms of life without parole on the homicide counts. The First District Court of Appeals affirmed Long's sentence. In a merit decision reversing the First District, the justices unanimously agreed that a trial court must consider youth as a mitigating factor when imposing a sentence of life without parole on a juvenile offender, and has considerable discretion in the weight the factor of youth deserves. But the justices split 5-2 on whether the trial court actually and properly did consider youth in this case. Justice Lanzinger wrote the majority decision holding that the record did not adequately show that the trial court specifically considered youth as a mitigating factor in imposing the sentence of life without the possibility of parole. Because the trial court did not separately mention Long's juvenile status when he committed the offenses, the High Court could not be sure how the trial court applied this factor. Significant to the majority was the fact that Long was sentenced along with the two adults in a group sentencing, and therefore his youth might not have been given the appropriate consideration. Quote, although Miller does not require that specific findings be made on the record, it does mandate that a trial court consider as mitigating the offender's youth and attendant characteristics before imposing a sentence of life without parole, unquote, wrote Lanzinger. The majority also issued a firm reminder that Miller suggests that such a penalty should rarely be imposed on juveniles. The case was sent back for resentencing. Chief Justice O'Connor concurred in the syllabus, judgment, and the opinion, but wrote separately to add a couple of points. The Chief wanted to make clear that all 7 justices agreed on 2 points. A trial court must consider youth as a mitigating factor when deciding upon a sentence for a crime committed by a juvenile, and that a trial court has broad discretion to determine how much weight to give to that factor. But the Chief also wanted to underscore the fact that judges have great discretion in sentencing, and that nothing in this decision changes that. What is added to the sentencing calculus is that an offender's youth must be an articulated consideration in the sentencing analysis, at least in cases in which life without parole is a potential sanction, O'Connor wrote. The Chief emphasized the fact that in remanding the case for resentencing, the court was not expressing any opinion on the merits of Long's sentence, which could remain the same after the proper considerations are undertaken. Justice O'Donnell dissented, joined by Justice Kennedy. O'Donnell has consistently been unsympathetic to juveniles who commit horrific violent crimes, especially those like Long, who was just shy of his 18th birthday. O'Donnell would find that the trial court did sufficiently indicate that it had considered Long's youth as a mitigating factor before imposing sentence, and the lack of a more substantial record on this point was because of Long's failure to present anything specific for the judge to consider. An update, what happened on remand is exactly what the Chief suggested. Long was given the exact same sentence, life without the possibility of parole. The trial judge made it very clear that she found the many aggravating factors, including Long's institutional behavior of fighting and procuring drugs since the original sentence, appalling. The case is on appeal again, but I don't think there will be any different result. A decision is also pending on a related issue which was just recently argued. In State v. Brandon Moore, who was a juvenile non-homicide offender, was given an aggregate sentence of 112 years for his role in rapes and aggravated robberies committed at age 15. He will be eligible for release at age 92. The issue is whether such a de facto life sentence is unconstitutional under Graham, which requires that juvenile non-homicide offenders must be given a meaningful opportunity for release. The next case is Daniel versus Daniel. Kristen and Sean Daniel were married in 1995 and divorced in 2011. They had 3 children. Sean had enlisted in the National Guard shortly before the parties married. At the time of the divorce hearing, Sean had 16 years in the National Guard. Sometime before the hearing, Sean re-upped for another 6 years. Sean will be eligible to receive retirement benefits once he's accumulated 20 years of service credit. When the parties divorced, the only real asset they had was Sean's military retirement benefit. The magistrate who heard the case found that a non-vested retirement benefit was not marital property subject to division under Ohio law. The trial court adopted the magistrate's decision over Kristen's objections, finding there were no retirement benefits for the court to divide. In a split decision, the 3rd District Court of Appeals affirmed. By a vote of 4-3, in an opinion written by Justice O'Neill for himself and Justices Pfeiffer, French, and Kennedy, the court found that unvested military retirements earned during a marriage are marital assets subject to division in a divorce or dissolution. Justices O'Donnell, Lanzinger, and the Chief dissented. One issue in the case that was very concerning to some of the justices, especially the dissenters, is that only Kristen appeared before the court. Sean did not file a merit brief in the case and was not permitted to argue. For that reason, Justice Lanzinger and the Chief would have dismissed the case as improvidently allowed. Key to the decision in the case is the section of the equitable distribution statute which includes in the definition of marital property all property that currently is owned by either or both of the spouses, including the retirement benefits of the spouses. The majority held that retirement benefits are included in the definition of marital property in the equitable distribution statute. The statute does not distinguish between vested and unvested retirement benefits. And the majority disagreed with the Court of Appeals' determination that Sean's retirement benefit could not be divided because its precise value could not be ascertained on the record presented. Fixing a precise present value in date of vesting is not mandatory, O'Neill wrote, finding that the trial court had enough information to make an equitable distribution of the retirement benefits. Well, how exactly is an unvested military retirement benefit to be divided? Kristen had argued for the use of the coverture fraction to do so. This method multiplies the retirement benefit by a fraction, of which the numerator is the number of marital years in the plan, the denominator is the total number of years in the plan. Simply put, the coverture fraction is just the marital portion of a benefit subject to equitable distribution. The majority cited this method with approval, but left the appropriate method to the trial court. But the majority was very clear that the trial court did have enough information to do this, and the case was remanded to the trial court for further proceedings. While there are 2 separate dissents in the case, all 3 dissenters agree on a key point. Unvested military retirement benefits are not marital assets subject to division. The statutory definition of marital property only includes benefits a spouse currently owns. In this case, the military retirement benefits are not currently owned by either party, can only be acquired if ever after the termination of the marriage, and may never vest. Until a pension is vested, neither party has a current interest as required by the statute, and vesting is a contingent event. Now here's an update on this case. After the case was remanded, the trial court ruled that Sean's unvested military retirement benefit earned during the marriage was marital property subject to equitable distribution. That, of course, was the mandate in the case. The benefit will be divided by applying the coverture fraction, which will yield the marital portion. But the total number of years of Sean's military service cannot yet be determined since Sean is still with the National Guard. Each party will receive 1/2 of the marital portion of the benefit when Sean is no longer with the service, but only if the benefit is then vested. In the event that Sean's military retirement benefit never vests, neither party will get anything. Sean was ordered to notify the court if and when the retirement benefits vest. The next case is Auer versus Palaia. Jamie Palaia was a real estate agent for Hometown Realty. Her contract with Hometown required her to pay Hometown 30% of all commissions she earned on real estate transactions. Unbeknownst to Hometown, Palaia set up her own property rehab and property management businesses. Tori Auer, a California resident, became interested in buying investment properties in Dayton, Ohio, and learned of Palaia's listings through an internet website. Auer arranged to come to Dayton to look at some of these properties and to meet Palaia. During this visit, Palaia told Auer about her own businesses and suggested the two begin rehabbing properties together. Auer was to provide the money. Palaia would renovate, manage, and sell the properties. Between October and December of 2007, Palaia helped Auer buy 5 properties, and Hometown got a commission on each of these sales. The business relationship between Auer and Palaia soon began to sour. Auer visited Dayton in 2008 and found the properties virtually uninhabitable. By 2012, the properties had no value and were scheduled for demolition. All told, Auer had invested over $430,000 in the properties. Auer sued Palaia and Hometown for misrepresentation and fraudulent inducement. Auer also sued Hometown directly for negligent supervision of Palaia, but abandoned that theory during trial and focused her claim against Hometown solely on the basis of respondeat superior liability. The trial court instructed the jury over Hometown's objection that if it found Palaia had committed fraud, Hometown would be vicariously liable for Palaia's fraud. The jury so found, and judgment was entered on the jury's verdict in the amount of $135,200 against Palaia and Hometown. The Second District Court of Appeals affirmed the verdict. In a 5-2 opinion written by Justice French, the court reversed, holding that the question of the vicarious liability of a real estate broker for the intentional misconduct of an agent is one of fact, not law. Justice Pfeiffer dissented, joined by Justice O'Neill. This is the instruction given in part that the trial court found to be incorrect. If you find that defendant Jamie Palaia committed fraud with respect to the sale of properties to plaintiff Tori Auer, then defendant Hometown Realty is vicariously liable, and you must find in favor of plaintiff Tori Auer and against defendant Hometown Realty. This is the charge the High Court found the trial court should have given. If you find that defendant Jamie Palaia committed fraud, and if you find Palaia committed this fraud within the scope of her agency, then Hometown is vicariously liable. The court writes no new law here. It merely follows long-standing precedent in the area of vicarious liability, namely that to impose vicarious liability on an employer, the jury must make a factual determination that the agent was acting within the scope of that agency when the tort was committed. The error here, both by the trial court and the appeals court, was finding this to be a matter of law. Here, to find Hometown vicariously liable, the jury would have to have found that Palaia committed the fraud, at least in part, with the intent to facilitate or promote Hometown's business. If what she was doing was strictly for her own benefit, then respondeat superior liability would not attach. The court took no position on the likely outcome here. It will be for the fact finder to determine on remand. Justice Pfeiffer, joined in dissent by Justice O'Neill, would find that the jury instruction taken as a whole was correct. I bring this case up as a torts professor because I continue to find the law on respondeat superior for intentional tort claims too protective of employers. Seldom, if ever, will an intentional tort be in furtherance of the employer's interest. Instead, I think the test should be that if a person's employment, whatever it is, enables the intentional tort, respondeat superior liability should attach. And I think the question should be decided from the point of view of the injured party. I particularly think the court reached the wrong result in 2006 in Grube versus Key Bank, in which the court held that in imposing respondeat superior liability for an intentional tort, it's not enough that the agent's position with the principal's business simply aided her in committing the tort. Pardon me. The next case is In Re AG. AG was born in December of 1995 to Lolita, a Russian citizen, and Patrick, an American citizen. They settled in the United States. Lolita and Patrick soon divorced. In 1998, in Henry County was where the divorce happened, and Patrick was originally granted custody of AG. AG became a ping-pong ball between her parents, to put it mildly. In February of 1999, Patrick, who had absconded with AG, was arrested in Florida. He'd been planning to take AG to Costa Rica. AG was returned to the custody of her mother. In February of 2001, the Henry County Domestic Relations Court approved a divorce between Patrick and Lolita, which resolved all the issues except child support and visitation. Within weeks of this order, Lolita absconded with AG to Moscow. A year later, AG was forcibly abducted from her mother's Moscow home, and the FBI believed that Patrick was responsible. Up to this point, Unsurprisingly, at this point, the Henry County Domestic Relations Court determined it was in AG's best interest that neither parent be her legal custodian or residential parent. So, in July of 2002, that court certified the case to the Henry County Juvenile Court. A court of domestic relations can send a case to juvenile court if it believes the child should not be placed with either parent. And when it does, and this is crucial to understanding the outcome and the majority holding in this case, the juvenile court steps into the shoes of divorce court in terms of what it can do. The juvenile court ordered AG placed in the care of the Henry County Department of Job and Family Services for her protection. The next day, Patrick brought her there, where she remained in the temporary custody of the county for 2 months. In September of 2002, the juvenile court awarded custody of AG to Lolita and granted Patrick unsupervised visitation. Then, both parents moved out of Henry County, Lolita to Ottawa County, Patrick to North Carolina. So the case was transferred to the Ottawa County Juvenile Court. The Ottawa County Juvenile Court appointed a guardian ad litem for AG, who sought a psychological evaluation of AG and her parents to determine what was in AG's best interest, and the court allowed this and interviewed AG in chambers. In July of 2008, Patrick was granted supervised visitation with AG, but only in Ottawa County. Patrick then moved for unsupervised visits in North Carolina, despite a letter from AG telling her father she had no intention of visiting him in North Carolina. Believe it or not, this is where the legal story actually begins. In October of 2009, AG got a lawyer who moved to terminate Patrick's then existing visitation rights. On October 21st, 2009, AG filed a motion for permission to attend her trial. She was then 13 years old, and her right to attend this trial is the legal issue in this case. More skirmishing. In February of 2010, the guardian ad litem became convinced that Lolita was intentionally alienating AG from her father and moved to grant custody to Patrick. The GAL recommended Lolita have no contact with AG until proper reunification occurred between AG and her father. Patrick joined the GAL's motion. AG and her mother opposed it. In preparation for a hearing on this motion, the judge interviewed AG in chambers and 5 days later denied AG's motion to attend the hearing. The judge found that AG would be represented by counsel at this trial, that her mother could also advance her interests, and that AG had had the opportunity to express her wishes to the court at the in-camera hearing. The hearing took place in early November of 2010. AG was then 14. The juvenile court denied a change of custody to Patrick, but granted Patrick unsupervised visitation in both Ottawa County and North Carolina. AG appealed the court's refusal to allow her to attend the visitation hearing. The 6th District Court of Appeals found the trial court did not abuse its discretion in excluding AG from the proceedings. In a 5-2 opinion written by Chief Justice O'Connor, the Supreme Court agreed. Justice Kennedy concurred in judgment only without further elaboration. Justice O'Neill dissented, joined by Justice Pfeiffer. I know I say that a lot. The court held that in ongoing child custody litigation arising from a divorce, a child is not a proper party and has no due process right to attend, but does have an interest in the action. In such proceedings, the court has the discretion to exclude the child if, under the totality of the circumstances, exclusion is in that child's best interest. Essentially, the court held that certification of a case to juvenile court doesn't change the domestic relations nature of the case. Under domestic relations law, once a domestic relations court issues an initial custody decree, it retains jurisdiction to modify that decree upon motion of one or both parents, but not by the child. By statute, only a parent and not a child has the authority to invoke the jurisdiction of domestic relations court to modify a prior order. When the case was certified to juvenile court, that court stepped into the shoes of the DR court, so AG continued to be unable to invoke the jurisdiction of the court to modify a prior custody order. The court rejected AG's argument that she had the same right as her parents to participate in the proceedings. The court summarily disagreed, noting that the constitutions, both state and federal, permit and sometimes require that children and adults be treated differently, and this is such a situation. On the due process claim, the court found that AG's due process rights were not violated. She had the chance to convey her wishes directly to the judge, and her lawyer and her mother both advocated her position at trial. In his dissent, Justice O'Neill, joined by Justice Pfeiffer, found that the trial judge totally failed to analyze whether AG was of sufficient age and maturity to attend the trial. In his view, the evidence in the case weighed strongly in favor of allowing her to be present. He would find that excluding her subordinated her best interests to her feuding parents and was an abuse of discretion. The next case is State v. Hoffman, which is a truly shocking case, a case of complete system failure. In November of 2011, a Toledo police detective filed 3 criminal complaints and requests for arrest warrants to a deputy clerk of the Toledo Municipal Court, charging Brandon Hoffman with the misdemeanor offenses of theft, criminal damaging, and house stripping. Each complaint cited the pertinent statute, the elements of the charged offenses, and contained a short narrative of the victim, the location of the offense, and the property taken. The deputy issued arrest warrants without making any probable cause determination. 2 weeks after the arrest warrants were issued, police responded to a call to Scott Holzhauer's house. They found Holzhauer's dead body and open and empty gun safe. One of Holzhauer's neighbors stated that a man named Brandon had recently visited Holzhauer and had been interested in buying guns from him. Further information identified Brandon as Hoffman, and a computer check disclosed the active misdemeanor arrest warrants. The officers decided to execute the arrest warrants. They went to the address listed on the warrants and found and arrested Hoffman. At the time of the arrest, they discovered a gun on the floor and a cell phone, both later identified as belonging to Holzhauer. On December 6, 2012, Hoffman was indicted for aggravated murder and aggravated robbery. Hoffman challenged the legality of his arrest and filed a motion to suppress all the evidence obtained on the grounds that the arrest warrants were invalid because they were issued without a finding of probable cause. Now, what came out at the hearing was really shocking. The deputy clerk who issued the warrants, and who had done so for the past 17 years, testified she had never asked an officer a single question, did not make a probable cause determination in Hoffman's case, and did not know what probable cause meant. She also denied that was part of her job to make a finding of probable cause. She just gave the officer the oath, issued the warrants, and entered them into the computer system. Toledo Municipal Court guidelines for clerks issuing warrants backed up her testimony. Nowhere in the guidelines are clerks instructed on making a finding of probable cause. The trial court found that the warrants were issued without a finding of probable cause, and that the procedures of the Toledo Municipal Court for handling complaints and warrants violated the U.S. and the Ohio constitutions. But the trial court held that suppression of the evidence was not required because existing precedent established in the year 2000 by the 6th District Court of Appeals in the case of State v. Overton established that a bare-bones complaint that only cites the statutory element of offenses satisfies the Fourth Amendment. After this ruling, Hoffman pled no contest to the charges and was sentenced accordingly. On appeal, the 6th District Court of Appeals concluded that the arrest warrants were invalid and first off overruled Overton. But the appeals court found that the arresting officers reasonably relied in good faith on existing precedent in getting the arrest warrants, and therefore the good faith exception precluded application of the exclusionary rule. In a 6-1 decision written by Justice Lanzinger, in which Justice O'Donnell wrote a short separate concurrence, the Supreme Court of Ohio agreed. Justice Pfeiffer dissented on his own. Justice Lanzinger began the decision with some fundamentals of the Fourth Amendment and its Ohio constitutional analog. Probable cause is required to search or to seize, and probable cause is to be determined by a neutral and detached magistrate, not by an arm of law enforcement. The purpose of the complaint or the affidavit is to provide enough information for the neutral and detached magistrate to determine personally from the facts whether it's likely that an offense has been committed by the person named. A mere conclusory statement that the person whose arrest is being sought has committed a crime is not good enough, and probable cause must be determined at the time the warrant is sought, not later. Clearly, the warrants issued were improperly issued in this case. No justice thought otherwise. But, as the U.S. Supreme Court has held, especially recently, just because there is a Fourth Amendment violation doesn't mean suppression of the evidence automatically results. Whether suppression is required is a separate issue from whether there's been a Fourth Amendment violation. Suppression is necessary to deter police misconduct. Hoffman argued that the 17-year pattern and practice of the Toledo police submitting bare-bones complaints, which were just rubber-stamped by the Toledo Municipal Court without any probable cause determination, was so egregious as to warrant exclusion of the evidence in this case. Justice Pfeiffer bought this argument and incorporated it into his dissent. The state argued that the exclusionary rule was designed to deter police misconduct and should not be applied to hold law enforcement responsible for the errors of judicial employees. The state further argued that the officers relied in good faith on the arrest warrants and couldn't reasonably have been expected to question their validity when the Court of Appeals in their jurisdiction had approved the procedure in question. The court agreed with the state that the good faith exception to the exclusionary rule should be applied in this case. That's an exception to the exclusionary rule created by the U.S. Supreme Court, which provides that the exclusionary rule should not be applied to bar evidence obtained by officers who objectively relied in good faith on a search warrant issued by a detached and neutral magistrate, but which is ultimately found to be unsupported by probable cause. This exception was later extended to the execution of invalid arrest warrants. The good faith exception was recognized in light of the high cost of exclusion to both the judicial system and to society at large. The majority rejected Hoffman's argument that there can be no good faith reliance on arrest warrants here because the deputy clerk totally abandoned her role as neutral and detached magistrate when she failed to make a probable cause determination before issuing the warrants. The court found there was no evidence that the deputy clerk colluded with the police or acted as an arm of law enforcement or was anything other than a neutral and detached magistrate. It's settled law that the good faith exception applies when the police act in strict compliance with binding precedent. Even though that Overton decision, decided by the 6th District in 2000, which approved this kind of bare-bones complaint, was clearly wrong, it was never overturned until more than a decade later by the appeals court in this case. So it remained binding precedent in the 6th District, and the police reasonably relied on it in good faith. Now, notwithstanding the outcome of this case in favor of the state, both Justice Lanzinger, who is from Toledo herself and was clearly embarrassed by what she was hearing, and Justice O'Donnell, in his separate concurrence, sharply criticized the practices of the Toledo Municipal Court in failing to determine probable cause before issuing arrest warrants for at least 17 years. The court made it clear that the procedure had to change immediately and that police officers could no longer rely in good faith on any warrants issued under the old system. Justice Pfeiffer acknowledged the draconian effect of the exclusionary rule, but would not apply the good faith exception under the circumstances of this case. He believes the police officer here should well have questioned the legitimacy of the warrant because the officer testified she was never asked to explain why she had probable cause to make an arrest. As he sees it, the clerk just served as a rubber stamp for law enforcement. He would find suppression necessary here to send a forceful message about this ongoing institutional, unconstitutional behavior in issuing arrest warrants. The court has also applied the good faith exception recently to permit evidence obtained from a GPS placed under the defendant's car without a warrant in a pre-U.S. versus Jones case, and also to allow evidence of illegal gambling seized with a search warrant issued by a probate judge who did not have the authority to issue it. The next case is Cedar Fair versus Falfus. Jacob Falfus worked continuously for Cedar Fair amusement parks for nearly 35 years. In 2005, he was promoted to chief operating officer pursuant to a written employment agreement. Falfus reported directly to Richard Kinzel, Cedar Fair's board chair, president, and CEO. In June of 2010, Falfus became aware of Kinzel's dissatisfaction with certain aspects of his work. The two men had a 94-second telephone call on June 10, 2010. It's undisputed that after this call, Falfus's employment with the company ended. Kinzel believed Falfus had quit. Falfus believed he'd been fired. The employment agreement between the parties contained a binding arbitration provision. The parties arbitrated their dispute, which resulted in a finding that Falfus had not been resigned, but had been terminated for reasons other than cause. So the arbitrators found that equitable relief was needed to restore the parties to the positions they held prior to the breach of the employment agreement and ordered Cedar Fair to reinstate Falfus to his former position. On appeal to the Erie County Common Pleas Court, the trial judge found that the arbitration panel's order of reinstatement exceeded its authority under the employment agreement. The 6th District Court of Appeals reversed, finding that the trial court erred in refusing to order reinstatement. In a unanimous opinion written by Justice O'Neill, the court held that the arbitration panel exceeded its authority in awarding reinstatement as a remedy for a terminated chief operating officer. The key sections of the agreement were Section 7, which provided that termination without cause would entitle Falfus to salary and certain health benefits for the then remaining term, and Section 11, which provided that if Falfus resigned, all benefits and compensation would cease on his last day of work. Section 19C provided that the panel had the authority to award any remedy that an Ohio or federal court would grant. Given the finding by the arbitrators that Falfus was terminated other than for cause, Cedar Fair argued that Section 7 of the employment agreement, which is a liquidated damages provision, controls, limiting the remedy here to compensation and benefits. Falfus argued that Section 19C of the employment agreement gave the panel the authority to order specific performance and thus reinstatement to his former position. The court agreed with Cedar Fair, citing the classic 1852 case of Lumley versus Wagner, in which the court held it did not have the power to order a singer who had contracted to perform at the plaintiff's theater to sing. In other words, courts cannot order specific performance of a personal services contract unless the contract or a statute specifically so provides, which is the bottom line in this case and the case syllabus. Justice Lanzinger had put it colorfully at oral argument when she stated to Falfus's lawyer that he seemed to be suggesting that the preferred remedy when there was a breakdown was to force a shotgun marriage. Several of the justices had commented that the company had clearly moved on and Falfus wasn't part of their plans. Exactly what compensation and benefits Falfus is entitled to and for how long isn't clear, and the case was remanded to determine that, but with the specific mandate that Falfus was not to be reinstated to his former position. The next case is Transtar Electric versus AEM Electric Services Corp. AEM was the general contractor on the construction of a swimming pool at a Holiday Inn in Maumee, Ohio. AEM entered into a subcontract with Transtar to perform electrical work on the project. Transtar fully performed the work under the contract and was paid $142,620. AEM did not pay Transtar the remaining balance of $44,088 because AEM contended the owner failed to pay it for Transtar's work. Section 4 of the subcontracting agreement included this provision, which was in bold and capital letters. Receipt of payment by contractor from the owner for work performed by subcontractor is a condition precedent to payment by contractor to subcontractor for that work. There are two types of contract provisions between general and subcontractors. A pay-when-paid provision is one in which a general contractor makes an unconditional promise to pay the subcontractor within a reasonable period of time to allow the general contractor to be paid. A pay-when-paid provision is not affected by the owner's non-payment. By contract, a pay-if-paid provision is a conditional promise to pay that's enforceable only if a condition precedent has occurred. Under this type of contract, the general contractor is only required to pay the subcontractor if the owner pays the general contractor. Under a pay-if-paid contract, the risk of the owner's non-payment is shifted to the subcontractor. The trial court granted summary judgment to AEM, agreeing that it was undisputed under Section 4 of the contract that AEM had no obligation to pay Transtar and the owner paid it for Transtar's work. The 6th District Court of Appeals reversed the trial court's decision, finding the language in the contract not sufficiently clear to transfer the risk of the owner's non-payment onto the subcontractor. Thus, the appeals court interpreted the contract language as a pay-when-paid provision, meaning that, as a result, AEM was liable to Transtar for the work performed whether or not AEM had been paid by the owner. It remanded the case for further proceedings, including the determination of what a reasonable time for payment should be. In a 5-2 decision written by Justice Kennedy, the court held that Section 4 of the contract between AEM and Transtar is a pay-if-paid provision, and clearly and unequivocally shows that the parties intended to transfer the risk of the owner's non-payment from AEM to Transtar. Condition precedent language shows that the parties intended that the risk of the owner's nonpayment shifts from the general contractor to the subcontractor. Additionally, use of the term condition precedent clearly expresses the intent to transfer this risk, and no other language in the contract is needed to do that. Additional language such as, in agreeing to this condition precedent, subcontractor assumes the risk of the owner's insolvency, would just add a belt to the suspenders and is unnecessary. So the Court of Appeals was reversed, and the judgment of the trial court granting summary judgment to AEM was reinstated. Justice O'Neill, joined by Justice Pfeiffer in dissent, would find the language in this particular contract inadequate as a matter of law to transfer the risk of nonpayment by the owner from AEM to Transtar. He would find the ambiguities in the wording that created genuine issues of material fact that made summary judgment inappropriate. The last case today is Schill versus Cincinnati Insurance Company. It's a case about domicile, but it arose in the context of a fight over insurance proceeds in a wrongful death case. While riding his bicycle in Geauga County, Ohio, Miles Coburn was killed by a car driven by Robert Schill. Robert was driving his own car, which was insured by a liability policy in the amount of $500,000. Coburn's widow, Peggy Spaeth, filed a wrongful death suit against Robert and his insurance company. Spaeth settled with the insurer. Robert then sought additional coverage under the personal umbrella policy of his parents, James and Jean Schill, as a definitional insured under their policy. Policy was issued by Cincinnati Insurance Company. In the declaratory judgment action over coverage, the trial court granted summary judgment to CIC. Robert assigned his coverage claims to Spaeth as part of a settlement, and Spaeth pursued the appeal of the trial court judgment. The 8th District Court of Appeals reversed, finding that James was domiciled in Ohio for insurance company purposes, and thus Robert was covered under the umbrella policy. The Supreme Court of Ohio accepted jurisdiction on the question of domicile. The umbrella coverage at issue was owned by Robert's parents, Jean and James. That policy provides coverage to a resident relative. Resident relative is defined as a person related to you by blood, marriage, or adoption that is a resident of your household and whose legal residence of domicile is the same as yours. Robert's clearly a blood relative of his parents, so the issue is whether Robert had the same legal residence of domicile as either parent. It was undisputed in the case that Robert was legally domiciled in Ohio. His mother was legally domiciled in Florida. So the resolution of coverage turns on whether Robert's father James's legal residence of domicile was Ohio or Florida. If Ohio, Robert would be covered under the umbrella policy, but if Florida, Robert would not be covered. So it's a very fact-intensive matter, and the court reviewed in great detail the facts supporting domicile in each state. James and Jean Schill had moved to Bonita Springs, Florida in 1993, when James intended to retire as CEO and chairman of his business, Chem Technologies. One motive for the move was Florida's lack of a personal income tax. The Florida house is titled solely in Jean's name. Florida has become Jean's permanent domicile and residence, but James, in his own words, flunked retirement. For years since moving to Florida, James has spent 2 weeks each month in Florida working at Chem Technologies. He leaves Florida around the 8th or 10th of the month and returns around the 20th. When in Ohio, James stays at Robert's house, which is about 13 miles from his company. James pays most of the operating costs on Robert's house, such as insurance, utilities, and real estate taxes. When James is in Ohio, he works about 12 hours a day. He charges Chem Technologies and a family partnership a per diem for those work days. James keeps a car at Robert's house. When in Ohio, James attends church there. His accountant, estate planning and business lawyers, insurance agent, and investment advisors are all in Ohio. So all of those factors favor Ohio as James's domicile. James has a second car that he keeps in Florida. He has a Florida driver's license since he moved down there. He didn't renew his Ohio license. He and his wife moved all their personal property to Florida. James has been registered to vote in Florida since 1993 and has not voted in Ohio since. His doctors and dentists are in Florida. All of his checking and savings accounts are in Florida banks. James receives his Social Security benefits by direct deposit in a Florida bank and does not file any federal, state, or local income tax returns that list Ohio's house as his residence. He keeps all his business records in Florida. James and his wife are members of a Catholic parish in Florida. And in response to questions, James answers that he considers Florida to be his residence. Now, these factors favored Florida as James's domicile. Then there's the tax issue. Florida has no personal income tax. James has always very carefully tailored his time to make sure that he spent less than 50% of his time in Ohio to avoid the presumptive evidence of being domiciled and thus taxed in Ohio. Only one time since 1993 has James spent more time in Ohio than in Florida in any given month. But here's the rub. By statute, to avoid a presumed Ohio domicile for tax purposes, a person must not only reside at least 182 days a year outside outside Ohio, but must also file a statement with the Ohio Tax Commissioner confirming that he or she is not domiciled in Ohio. James has never filed such a statement, and Spaeth made this a centerpiece of her argument as to why James thus cannot be presumed domiciled in Florida. In a unanimous decision written by Justice Pfeiffer, the court held that a domicile means the place where a person resides, intends to remain, and to return when away temporarily. In this case, the objective facts in the case combined with James's statements of intent clearly established Florida as James's domicile. As for Ohio, the nature of his contact with Ohio is transient. He works and then he leaves, Pfeiffer wrote. James's regular work activity in Ohio does not contradict an intent to make Florida his permanent residence, nor does it change the fact of his residence in Florida. James's clear intent was to work part-time in Ohio and be domiciled in Florida. He has meticulously ordered his life to make that so, Pfeiffer wrote. Now, the High Court gave James's failure to file the requisite tax form far less weight than Spaeth had urged. The court noted that failure to file the form would mean that James would be presumed to be domiciled in Ohio for tax purposes, but the statute also provides that a person can rebut the presumption with a preponderance of the evidence to the contrary. The court noted there was no evidence that James had ever been challenged by Ohio about his domicile, and that his own testimony showed he could rebut that statutory presumption against his Florida residence. So the effect of this decision is no umbrella coverage for the widow in this wrongful death claim. Thank you for your attention today.